Yeah, we are going to go with okay. So where am I? Okay, fine. Okay, yeah. So I was just trying to know like switch on the camera. Yeah. So yes, a very good evening to everyone. And so this session is going to be no the continuation of our last session. So it was all about administrative law. Let me take you to the topics, no, like which we have discussed last week on this particular subject. So we started off with what is mean by administrative law, and who are the parties involved in the administrative law. So the government and the the organization, or the government and any individual or agency, so who get into a contract. The government offers, no, like any government, take any government for that matter, it offers an activity or a work to do, that is they outsources some work, for the benefit of the society. So the organizations who are interested to take up the work for a mentioned price, for a mentioned cost, so they will be, no, like accepting that offer, nominating themselves for that offer. That is nominating their organization for that offer. And this government sector, the public sector, they select the right activity, that is, no, like the resource providers. So once a project is done, once the activity is done, so these organizations hand over the project, hand over the completed project to the government. So they get no like benefit out of it. They will be getting paid for it. So this is all about no like so the law which governs and manages and no like make sure there is no there is no fraudulent activities happening in this particular activity, in no like offering the contract, accepting the contract, and no like executing the activity. So where does the law stand here? Where does the law no, like has its scope here? So it no like makes the rules and regulations, it makes the law, the law authority, it makes the law, creates a law which is no like acceptable and is common for both the parties, or all the parties no involved in this activity or involved in this project. So then we again know like went in depth about no like seeing how these administrative laws are formed in no like in governments, that is no like governments of any country for that matter, like how they know like propose the administrative laws. So it's no like all the doctrines, all the important points from no like the mercantile law, the based on the customs and usages of that particular country, the judicial decisions and the country statute. So all these no information are no like gathered from each and every aspect, and finally the law is formed. Then what is the role of contract in administrative law? Because if it is a project, the government offers a project, or a government agency offers a project, and the other player, that is the opposite player, that is the another organization or company or agency or individual for that matter, so they accept the offer and they both get into the contract. So in the contract, all the information will be mentioned, like when to start the project, what is the total cost of the project, and when will be the end date of the project, who are going to know like take participate in that particular project, so how long it's going to go, how it will be executed. So everything know like people know like who are involved, know what are their roles and designations. Completely all the information will be like mentioned in the contract. So both the parties will come and sign the contract. It means they are accepting, both the parties are accepting all the norms and all the regulations in the contract. So with the provider, the like the service provider, there is no like who is no like getting the project from the government sector, or no like a public sector, public company. So what the company, that is the player has to do is make sure they are no like completing the project on time as mentioned in the contract. So then we went on with like what exactly is a contract and the contract formation journey. So starting with an offer or proposal, the government offers a proposal, so the parties accept it, and so they join hands, no, like all the negotiations, everything will be, no, like discussed upon, and a few considerations will be, no, like give and take policy will be there, and finally they agree to all the terms and conditions, and final legal enforceability, that is signing on the contract, will be done. So this is how, no, the contract will be, no, like um, enacted. So we went through, no, like all these points. So each and every point we discussed on it, and there are, no, like few classification of contracts. Not all the contracts are one and the same, or the players cannot. That is, no, like the players in this particular, no, like administration activities, they cannot, no, like make, or no, they cannot use the same type of, no, contract for all the projects. So based on the, like the surroundings, based on the environment, based on the parties involved, based on the creation, no, like on many aspects, there are, no, like various classifications of this contract. So first one we saw was by creation and formation, and then we saw by validity, till, no, like will, till what time, no, the contract is valid, and the third classification was by execution and performance, and the fourth one was by liability, that is who is which party is liable for which activity. Then we then had an overview about the offers. That is not the government, the public sector has to, give the offer. That is not like open up with the project, right? So this is a project, no, like we are planning to have. So who is ready to execute it? So the project, no, like all everything about the project will be, mentioned in the offer. So companies who are willing to take up the project, so they, fire, no, like accept the quotation, and sorry, they, like create a quotation, and, no, like they submit it to this government sector, and it may be, no, like on the basis of bidding, or no, like whether maybe, no, like bidding, through bidding, or through any other means, no, like the government, the public sector will select one organization or an agency to take up the project. So types of offers, no, like express offers are there, and implied offers, specific offers, and standing offers, counter offers, and cross offers. So then we saw about, no, like the Indian administrative law, when it was, no, like enacted, when it was passed, when the bill was passed, and, no, like the two main parts in the administrative law. Yes. So now we are, no, like today's session we are going to discuss about many important points. So all the discussions we had last time was, no, like completely about what a contract is. Now this session is all going to be about, no, like how this administrative law will be, no, like executed. So when we say party, we say, no, like government is no one of the player, the agency or an individual or an organization who accepts and takes a project, no, like that person or that entity is another player, and the providers, no, like suppliers, the vendors of the, no, required materials, they are one player, and the legal authorities, no, like they are the players. So customers, consumers, the final persons, no, like who are going to utilize the no, the project, the benefit, no, like which they, get out of that project. So everyone knows is a player here. So since it is going to be, like the project executed by say, like the government itself, so it has, no, like various benefits for the public, so various benefits for its citizens. At the same time, any company, like if they are accepting, if they are ready to give a project, complete a project completely free of cost, so maybe, like on some like societal, on the basis of, like societal terms, or no, like they are ready to contribute something to the society, at their own cost. In those cases, organizations can, like take up the project, complete the project completely free of cost. They don't have, they will not be getting, like any monetary benefits, out from the government, but they may be getting, like the other projects, like the after projects, because of this decision. Because no, like the government believes them, like they will give the better, like the projects will be like delivered in a good way, in a better way, and like on time. If we can, if we are going to give to this organization. So few companies, yes, construction companies or like infrastructure companies, yes, they do that. Their first project, like the government project, sometimes no companies they execute it completely free of cost. So they see it as a like a social responsibility factor, corporate social responsibility factor. So they do it. In that case, if contract, if you ask like whether it's contract available, yes, for any type of like government projects, contract is a mandatory one. Even though if the company is willing to execute it completely free of cost, contract is mandatory. So let's see about like the important points like on this administrative law. So first one is administrative agencies and their powers. So who are these administrative agents? Who like looks into these the complete activity of like the project execution? So these agencies are specialized government bodies created to implement and enforce specific laws and policies. They operate with delegated authority from the legislative and executive. So what is legislative? Legislature or legislative is like the government, the ruling government, and executive is like the enforcement. So and like other than that, we have this law entities, and we have this like the unions. So all these people, all these parties come together to make sure the project is like executed in a better way. So important points to note in this administrative, about these administrative agencies is, so there are regulatory agencies, there are like executive departments, there are independent commissions. So all these agencies like they take part in administering the law, whether when the the contract is being executed. And constitutional limits on legislative delegation to agencies, so that is like done by these like administrative agencies. And power, like so who has the power to to execute this law? All these three parties, that is the agencies, the legislative and the executive. So all these three parties have the power to execute the law. Say, for example, your company is taking up a government project, some infrastructure project, like building, maybe, like I could say, building a bus stop. Okay, so building a bus stop, a service stop for the public. So in that case, like, so your company will be accepting the offer, which is like forwarded by the government, and your company takes up that project. You have the timeline, you have like get the required resources, and your company has to execute it and complete the project within that timeline and hand over the project to the government for the public use. So in this case, like if you want someone to like monitor what is like going on between you and the government, that is like between your company and the government. So all the communications, all the negotiations should be like having some like some entity who governs all these. So these parties, these legislative and the executive parties, agencies, so they take care of those things. And accountability. So accountability is like it's based on judicial review and executive control, legislative oversight. That is like if anything wrong happens, it may be from the government side or it may be from your company side. So who will decide like uh, both the parties will be like putting the blame on the others, blaming the other one. So somebody has to like be like a mediator, uh, understand the like what has happened actually, and like give the accountability. So after like they thoroughly processing and like analyzing each and every incident or each and every activity, so they will make accountable, they can either make the government accountable, or either they can make your company accountable for the the error that has happened. So these parties, they have that power. And expertise justification, they can justify with required sources and proofs, everything, these agencies possess specialized knowledge in technical areas as well, so they can do the justification. So they are they have that power for it. So examples, examples of these commissions, administrative agencies or FDA, EPA, FCC, and Securities Commission. It depends on the countries. Each and every country will be having different administrative agencies. So these agencies are the very powerful agencies. They have all the right to monitor the process, monitor the project, question the parties. Even if it is a government, they have the right to question them, and they can give judgments. They can justify, and it can make the company or the government accountable for any error which has happened. Second one is rule making procedures. So who makes the rule?
Ma'am,
Who
I
makes
want
the
to know,
rule
please.
for? Mhm.
Yes. Delegation doctrine. Can you repeat, please?
Sorry.
Delegation
Delegation,
doctrine.
delegation
Yes.
doctrine is which party has the has to do which activity. Who is responsible for what? So if it is an activity, if it is a transaction, who has to do that? Either the government or your company. Who has to do it? So that is delegation doctrine. So it will be already clearly mentioned on the contract. So all these agencies, they just take care of the contract. That is contract is a valid, a legal documentation, right? So that is strongly, proposed by these administrative agencies. Delegation doctrine is the doctrine which has clear, which has points which clearly mentions which party has has to do which activity. Clear?
You.
Yeah. Okay. For example, take sourcing. You have to source the raw materials. So if it is say the project is about constructing a bus stand, okay, a public bus stand. So what do you need? You need resources, right? You need the basic resources such as cement and mortar, and you need people, manpower to construct it. You need machines to for carrying the materials from here to there. You need cranes, so you need everything, right? So you have to source all these materials from the required from those vendors, right? So you cannot wait the government to do sourcing for you. You're accountable, your company is accountable for that. So who is going to do the sourcing? Who is going to transport all the materials to the no the place where the construction is going to happen? So these activities will be clearly mentioned in the doctrine. Clear? So finally, if you're delaying the project, waiting for the government to supply the materials, so they cannot check the doctrine and say, no, your company is responsible for that. So how can you wait for the government to give you the required materials? Is it clear? Yeah. Is it clear? Okay, fine. So, second one is rule making procedures. Just give me a second. Let me switch on the power because maybe the system is going to shut down. 1 second. Just give me a second. Sorry for the the delay. Okay, so let's start. So second one is rule making procedures. So rule making is a process by which administrative agencies create legally binding regulations to implement statutory mandates. That is who makes the rule here, whether it's the law or it's the government. So government and law both take part in rule making, and along with them, these administrative agencies are also responsible for rule making. So important points to note, no, like in this, like the topic is formal rule making. That is trial type procedures with hearings, cross examination, evidence presentation. It's possible. It's just like, no, like you're appearing before the court. So if anything happened, no, like if any error has happened, so these administrative parties, no, agencies, they have to, get an insight about what has actually happened, whose fault it is. So there will be no like hearings, just like in no like normal court, there will be hearings, there will be cross examinations, and evidence presentation can be done. If your company no like feels that no like uh, they didn't do anything no like wrong, or the error that didn't happen because of them, if they have that proof, they can very well no present it to these administrative agencies. So that is formal rule making. That is not like providing the proof. Informal rule making is notice and comment procedure. That is the most common method. Just sending a notice to your company asking what really has happened, or no like about some activity, or about some no like an error. So what is your company's opinion on that? So notice requirements is publication in official gazettes, adequate description of proposed rules. So they can know like even publicly display no that there is a dispute between no this government and this particular party. Then public participation, public hearings, stakeholder consultation. So that will also done by these no administrative agencies. And economic impact assessment requirements. That is cost benefit analysis. So that will also be done by these administrative agencies. So they will come to know which party profits no better in this project. So at the time, if they want to negotiate something, change something, yes, they are no eligible. They have that right to do that. They can change even after the contract is signed between your company and the government. If the administrative agency want to include one more point, or delete one point from the contract, or edit some points on the contract, they can do it. And final rule publication, statement of basis and purpose. So why this is being formed, and response to significant comments are sorted. And emergency rule making is expedited procedures for urgent situations. So if the issue is so serious, which needs solution immediately as soon as possible, then expedited procedures of hearings, cross examinations, and evidence presentation, yes, it can be done. So next one is administrative adjunction. So this involves agency resolution of disputes through quasi-judicial proceedings, determining rights and obligations of specific parties. So we have already seen what is known like a quasi-contract. Quasi-contract is both the parties will not have a doctrine and sign in the contract, but according to the government, according to the rule, or according to the law, so both the parties have to do no like few things mandatorily. Without even signing the contract, few things they have to do mandatorily. For example, say your company has no like accepted the offer. There is no like you're ready to, your company is ready to construct a bus stop no for the public. So even though this point is not mentioned in the doctrine, say no like you shouldn't destroy, you shouldn't no like cause any destruction to the next property, no the very next property which is close to the the place where the structure is going to come. So the very next property, no, it may belong to a private party, or it may belong to a government one. So you shouldn't destroy, you shouldn't cause any destruction to them. Clear? So this is a normal, no, like the usually the law which we follow. We don't know like make any damages to the no like the nearby buildings, or no nearby premises. But even though it is, if it is, this point is not mentioned in the contract, it becomes a no like a quasi contract, because as per law you shouldn't do that. So it's a criminal offense, you shouldn't be doing that. So important points in this topic is, so administrative law judges, that is specialized officers, they conduct the hearings. There are specialized officers, and the hearing procedures are no like evidence rules, witness examination, and burden of proof. Based on the burden of proofs, that is no like checking the weightage of the proof, they can no like give the verdict. And due process requirements is notice, opportunity to be heard, impartial decision maker. That is, you will receive notice to appear before them, and whatever no like you say, yes, it will be heard by them, and they will take decisions no like impartially. They will not be partial to no like any of the parties. So types of proceedings is license revocations, enforcement actions, and benefits determinants. It is not like if your company is found guilty, they can no like revocate your license, or no like they can enforce any no like actions against your company. And benefit, like, that is not like this the claim no, the cost for the damage, and no like the claim for the damage no like who is going to be no like uh, I mean, no, like which authority, no, like gets that claim. So that will be decided by them. Then official record creation for potential judicial review. Yes, they are doing it. They will be doing it. Internal agency appeals, administrative review, both are there. That is internal agency. Instead of no like going to the final no, or the no like the most senior authority. So within the no like the junior authority level, you can no like resolve your disputes no with the other party. And the finality requirements, exhaustion of administrative remedies before court access. That is no like if administrative remedies doesn't work, then no like you can no like appear before the administrative court. That is no, there is a special court for it, so you can no like appear before them. There is no like you can file a case against the other party. So if things doesn't work with this administrative agency level, that is the conflict between your company and the government, it didn't get resolved, it didn't get sorted out in front, that is no like with the help of this administrative agencies, then the next step is you can go completely legally. So fourth one is judicial review. So court reviews administrative decisions to ensure agencies act within their authority and follow proper procedures. So who is going to administer these administrative agencies? So it's the court. So reviewability, presumption of reviewability versus committed to agency discretion. So agency may take any like decisions. They can delegate the authority to any of the parties. They can impose fine on any of the parties, either of the parties, based on the proofs and based on no like other factors no which they have in hand. But again no like if you want to go for a re-appeal, you can no go to the court. So the court again no like reviews everything and it can take its own decision. So injury in fact, causation, redressability, so these things no like it has to be clearly defined, mentioned, and proof has to be shown. And timing issues is rightness, finality, statutory of limitation. Rightness is before no the project deadline. So if you have exceeded, your company has exceeded the timeline. So you're supposed to know like a hand over the project, complete the project and hand over it to the government, say by no like say July 30th, but July 31st. But no like your company cannot complete it. So you're exceeding the timeline. So in those cases, no, that's called rightness. And finality, that is final handover of the project, or statute of limitations. So up to maximum which time, no, like line, which timeline you get, no, like you can complete your project. The government sometimes, no, like gives extended time, extends the time of completion. So even after that, if you're no, if your company is not able to, know, like complete the project, then no, like there is a serious issue. So standards of review is questions of law, questions of fact, and mixed questions. Questions of law is de novo review. Sorry, de novo review. De novo review is so at the base level, at the with the executives who are in the base level of this administrative agency. So they will know like hear your case. If they are not able to solve, or if they have given some wrong judgment, if you feel in that way, your company feels in that way, then very well you can go to the higher authorities. And even with them, if you feel no like no like the there is no proper jurisdiction, So then you can go to the court. So finally you can go to the court. So the court, what it can do is, without considering the all the proofs which like which has been produced before this, like junior executives and the senior executives of the administration agency. So even without like going through all this, the court can themselves, it can itself like give a new verdict on the issue which has happened. So that's called de novo review. So questions of fact, substantial evidence standard. So that has to be proof has to be like very strong, and it varies by jurisdiction. So base level, junior level, no executors, they may give different justice, and senior level they may give different justice, and like court it may also give different justice. So it varies, like varies on the parties, varies on the proof, which you have in hand, that is your company has in hand. An arbitrary and capricious test is rational basis for agency decisions, and Chevron difference. It means courts defer to reasonable agency interpretations of ambiguous statutes. Ambiguous statutes is if the administrative agency is not sure about like what verdict it has to give. So after like analyzing for a long time, so they are giving like a verdict, so which your company doesn't accept it. So in that case like you can like appear for the, you can like file it in the, file it with the higher authorities and then with the court. So remedies: remand, set aside, injunctive relief. So whichever party is found guilty, so they will be remanded or they will be set aside from the project, or some injunctive relief will be given. Fifth point is due process in administrative proceedings. So this ensures fairness in administrative proceedings, protecting individual rights from arbitrary government action. So I say finally, like the administration agencies, these agencies has decided like they have to like take back the project from you, and seize back the project from you, and they're planning to like give it to another company. Even after you have like spend a lot of money, your company has spent everything, like time, energy, money in like procuring the materials, like sourcing the other required resources like manpower. So after spending so much of like time, energy, and money, now the government, that now these administration agencies have decided to seize the opportunity, like seize the project from you, and like they are planning to give it to other party. So in this case, like again like if you feel that like this is not right, so it can like go to the arbitrary council. So arbitrary council is, they will, before going to the court, they will like make you, and that is make you a company officials and the government officials like they like they make them to sit together, and they discuss about like what went wrong, like whose fault it is and everything. So after finding the like the truth with the like the proof and everything, so they can decide on it. So procedural due processes, fair procedures before deprivation of rights. So without this, any court or like any like agency, superior executives in the agency, or those like base level executives in the agencies, so whatever like jurisdiction they give, you don't have to like go with it. If you are very sure about the fault is not like on your side, that is not on your company's side. If you're very sure about it, you don't have to like accept it. You can like file the the case with like the higher authorities. So protection against arbitrary government action will be given, and adequate timely notification of police proceedings will be given. Even if they have decided to like take over the project from you, so they will give you adequate time to like to receive back, and opportunity to present a case, confront evidence, so that rights will be like be given to your company, and freedom from bias and conflicts of interest, and varies by type of proceedings and stakes involved. Usually burden of proof is, there is like how much weightage is given to like the proofs. You have like at least 4 or 5 proofs from your company side, and from the government side they too have some proof. So how the weightage is given? So usually preponderance of evidence in administrative settings, that is not preponderances you say that the more truth, like which proof is having the more truth into it. So based on that, the weightage will be given. And a written decision, that is recent explanation of findings and conclusion. So you want to know why the project has been seized back from your company. They will give you a detailed explanation for what reason this project is taken back from your company. So next one is, yeah, okay. Okay, so freedom of information and transparency. Laws requiring government transparency through public access to information and open decision making processes. So the laws, like which give, like which protects the parties involved in this contract or involved in the project. So it has to be, like very transparent, because like the public has to know whose fault it is, like, or no, what about the like project, what project it is, so how it is going to like benefit them, and who is responsible for taking over this project, which company or which agency. So what is the total cost of the project? So you might have like heard the information like through news channels or through like any government media channels, that a project is going to happen. It will be done by the government. So the total cost of the project, the whole cost of the project is this. So why it is given to the public, why the government has to give all this information, even the total cost, why it's given to the public? Because it's public's money, right? So they have to know like where their money is going. So it is mandatory for the government or for any agencies to be very transparent about what project they are going to undertake, and till what time like this project goes on. There is a deadline of the project, timeline of completion of the project, and which parties have like taken the responsibility of completing the project. So what is the total cost of the project? So public has the all the right to know about this. So public right to government records and information, yes, it's no like they are eligible to like know about it. Proactive publication requirements, application processes, time limits, free structures. They have to know national security, privacy, commercial confidentiality, deliberative processes, and internal reviews, information commissioners, court appeals, digital governance, online portals, searchable databases. So this is to be transparent, right? This project has to be very transparent. So even if the public know if they know want to know more about this project, they want to know the truth behind this project, so very well they can get it. And open meeting requirements for government bodies, and safeguards for those exposing government wrongdoing. Not only that, if any party comes to know about the error has happened from the government side, so and they know they declare it in the public, or like through any media, they publish that information to the public. So these administrative agencies has to know safeguard those agency or those individuals. They are usually called as whistleblowers, right? So they have to know safeguard these people, because after that the proceedings will be done, whether this person said something, whether it's true or not, so whose fault it, if it has been if it is already done, then whose fault it is. So if they have found that it's government fault, then they will get the compensation from the government and pay to your company. Or if your company's fault it is, then they will get the compensation and fine your company, and yeah, give the money to the government. Administrative discretion and its limits. So, administrative discretion refers to agency flexibility in decision making, balanced against legal constraints and accountability requirements. The sources of discretion is statutory grants, policy choices, and enforcement priorities. So, types of discretion is prosecutorial and rule making, adjudicatory, and remedial. So it can be any kind of discretion. This discretion is nothing but the decision. what final decision no like they have come up to. So prosecutorial, so you may be your company or the government may be prosecuted, that is no like punished. Rule making, adjudicatory, that is adjudicatory is without giving any no like verdict, they can just resolve the case and no like ask your company and government no like not to get into conflict and go on with the procedure. And finally no like remedial, but if in case no like if there is a fault found, so whichever party is being no like affected by it, so they get the remedy. Abuse of discretion, so if this decision is abused, then what happens is arbitrary action will be taken. Failure to consider relevant factors, that is they don't worry about it no like the whether your company no like will lose its brand value, or whether the government, the running government will lose its brand value, they don't worry about it. They just know like punish whichever party know who abuses the discretion. Then is judicial control. They review the standards and reasonable requirements. Policy considerations is expertise, efficiency, political accountability, and there are limiting factors for this. There is statutory constraints, constitutional requirements, and precedent. Few like restrictions or no limitations are there, like administrative these agencies, they cannot execute everything no like whatever they have decided for. So there are few restrictions like constitutional requirements, they have to know like abide to that, they have to consider that before giving the, before making the decision. And guidance documents is non-binding agency interpretations and policies, that is they don't allow any external party to involve in the decision making process. Consistency requirements is equal treatment and predictable application. So what is the use of no like these fundamental principles, so how it is no like useful. Sorry, yes. So here on the other side, the thing is no like they won't be partial at all. They will always know like uh, hear the other parties as well. So what the other party has to say. That is right to notice of case against you, opportunity to present defense, right to know evidence and charges, reasonable opportunity to respond. It means right to notice of case against you. That is no like if the case is filed against you, that is your company by the government, so they have the right to know like notice it. There is no like they can give you notification, and no like opportunity to present defense. You will be given an opportunity to present your defense. Right to know evidence and charges. There is no like you have, your company has all the right to know. So what proof, what evidence this government has no like put forward, so that no they are questioning us. And charges no like what charges no we have to pay in case no if we are found guilty. Then reasonable opportunity to respond. And the next one is no one should be judged in their own case. That is nemo jurex in causa sua. So freedom from bias and conflict of interest. So there will not be any like partiality shown. So freedom from bias and conflict of interest. Appearance of bias test, institutional versus personal bias, that is no like completely it's institutional based and not on personal. Then recusal requirements. So recent decision making will be completely based on rational. So all the factors will be considered. There will not be any bias or partiality, and consideration of relevant factors will be taken into account. So punishment fitting the violation. That is no like whatever punishment no like that fits the violation should be given. It shouldn't be something no like which doesn't fit the violation. For example, like when constructing the bus stand, no like one of the worker no like have caused a small damage to the next property, the property no which is very closely no which is very close to the construction site. A very small, a minor damage. So for this reason, no, like the project shouldn't be seized from you. So your company can pay the compensation to those, no, like the building owners or those landowners or whatever. So your company, if it is ready to pay the compensation, then no problem. No, it's completely negotiated. So this for this reason or no, like taking this as a chance to seize the no, like opportunity from you, the government shouldn't take any decision. So punishment fitting the violation. So you will be charged, like fine, you will be fined for that. But for this reason, they cannot seize the opportunity, seize a project from your company. And legitimate expectations, protection of reasonable reliance on government representations. It should be reasonable. It shouldn't be something unreasonable. The next one is remedies in administrative law. So what remedies your company can get? So legal remedies available to challenge administrative actions and obtain relief from improper government conduct. So your company is eligible for that. If you find the jurisdiction, the verdict given to your company, so it's not acceptable at all. Because like from your company side, there is no fault. If you're very strong about it, you don't have to agree to their decisions. You can like go to court. Finally, you can go to the court. So prerogative writs, that is like certiorari, quash illegal decisions. So illegal decisions you can fight back, and mandamus, that is compel performance of duty, which is not mentioned in the contract. So against that you can file a case. Prohibition, prevent ultra virus actions, small actions, so for that reasons you can you can file a case. And quo warranto, that is challenge authority to hold office. There is like, because you have taken a government project, it doesn't mean government authority can involve in your management decisions. It's your company decisions, it's your own company. They cannot involve in your management decisions. So if they are purposely taking part in that, purposely getting into it, you can file a case against them. So declaratory relief is court declarations on legal rights and duties, and injunctive relief is court orders stopping or requiring agency action. So they can stop the action which is taken against your company. They can do it. And damages, monetary compensation for losses. So your company will be paid for that if your company is not found guilty. Restitution, return of improperly collected funds. If the government has already collected funds from your company, and if it is like a wrong one, they can get it back to your company. So refund that can be done. So appeals and revision, internal agency review mechanisms. Through these mechanisms, appeals and revisions can be done. And interim relief, say stays, temporary restraint for orders during proceedings. Interim is intermediary. That is temporary, like not the final judgment, but the temporary judgment for some time. So stay, they can give a stay order, so that you have to stop all the proceedings, stop the activity, stop the project as it is. So after, when they have given the the judgment or the verdict to to go on with the construction, your company can go on. Till that, no construction has to happen. Only after the stay has been revoked, the construction has to resume. And finally, ombudsman and alternative dispute, this dispute resolution. So ombudsman or those agencies, or a group of uh, law, not law making, but who are uh, you know like appointed by law. Appointed, that is the right word. Yes. So ombudsmen are those no agencies, or experts who are appointed by the law. So they have all the rights to, on behalf of the court, on behalf of the legal body. So they can take up your case, see what has really happened. Then they can give their verdict. They can make the negotiation happen between your company and the government. And whether there is an involvement of compensation or fine, whatever. So ombudsmen they can do it. Since I said man, it doesn't mean only male representatives has to be there. So it's a common term, it's there is it's not gender basis. So experts, it can be any experts. These experts can be high officials in government agencies. So there can be anything. And they can be retired judges, they can be retired policemen. They can be policewomen or they can be anything. So this group of ombudsman or no like any individual ombudsman can listen to the case filed by you against the government or the case filed by the government against your company, and they can no resolve the issue, resolve the conflict. So why we are going to ombudsman no instead of going to the court is, so court it will take its own time to give the verdict, final verdict, because no like many cases no like just like your company and the government has, it deals with many cases, the court. So they don't have time to know like immediately they will not look into your case. So till that time no like your construction will be stayed, the construction, the activity, the project will not be happening. So only after the verdict has come you can be you will be continuing with the project, right? So if you want immediate relief and if you feel that no like if we go to court, the problem between no us, our company and the government, it will be known to the public. So you don't want to spoil that reputation or no about your company, no. So you don't want to know spoil that brand. So what you're deciding is, before going to the court, let me know, like check with the ombudsman, let me know, file the case against the opposite party to the ombudsman, and let the ombudsman decide who is on the wrong side. So yes, these ombudsman, they actually know this group or this individual actually acts as a court. They listen to your hearings, they see the proofs, they check the evidences, the weight, they give weightages for the evidences, and finally, they declare their verdict. So, Ombudsman institution is independent investigator of citizens' complaints, informal resolution of disputes. So, for you, there is no need to go to the court. Systemic reform recommendations, annual reports, and public accountability. So types of these alternative dispute resolution people are mediation. They do the mediation, that is neutral third party facilitation. They will do it. And arbitration. Arbitration is negotiation. So binding the third party decision, negotiated rule making, collaborative rule development. That is, they can make you and the other party, that's your company and the government. So make you two people know like two factors know like collaborate with each other for the better development, and settlement conferences, pre-hearing resolution attempts. So what are the advantages of having no like appearing to ombudsman, no like seeking the guidance and help of ombudsman instead of going to the court? So speed, yes, like you will get your verdict no like as soon as possible. So then cost effectiveness. So if you're going with no like court proceedings, you have to spend a lot of money. So preservation of relationships. So yes, like if there is a good negotiation happening and both the parties know like your company and government has no like again collaborating with each other, so you can preserve that relationship, right? So there will not be no like any haste on that relationship. Limitations, not suitable for all disputes. So enforcement issues, so it's not suitable for all the issues. The issue is very serious, it has to be more evidence has to be like produced, then you have to appear for the court only, not to the ombudsman. Grievance redressal, formal complaint mechanisms with agencies, citizen charters, service standards and accountability measures, and online dispute resolution, digital platforms for complaint resolution. So through digital ways also, you can file the complaint, you can provide the evidence, you will get your verdict through digitally. So finally, like there are few things to like keep in mind. The core principles of this administrative law is balance of power. So it doesn't mean since the government is involved, they have all the power. So balance of power is there. No partiality will be shown for any of the parties, and fairness first. So very fairly like very truthfully they conduct the process. Transparency matters, so the more transparent the government and your company is about the proceedings, about the project and everything will be good. And practical applications, exhaustion doctrine, that is you must typically go through all the administrative remedies before seeking the intervention. So go through your contract like if sometimes we may miss out a point or so in the contract. We may think, okay, we usually do in this way, our company usually do in this way, so let's do the same thing even in the government contract. No, it doesn't like go like that. Sometimes no, like those things may change if you're involved with the government contract. With a private contract, that's different, but with the government contract, no, like things may differ. So you have to go through each and every line, understand and learn each and every point in the contract, and get to know that whether the, the error is no, like really has happened, and if it really has happened, whose error it is, and then no, like decide whether you want to appeal or no. And standing requirements to challenge any agency action, you have that no, like power. And evidence standards, you are no, like you have all the no, like rights to produce any evidence, no, like for getting more weightage. So strategic insights, multiple remedies, information access, due process, and everything is there. And strategic insights says timing is critical. So whether if you want the immediate action to be taken, you can no, go to ombudsman, or if you need to produce solid proof, it will take some time. But no, like, and the compensation money is more. The loss is no, like the value of the loss is no, like little no, like big. So in those cases, you have to appear to the court only if you're not happy or satisfied with the verdict given by these administration agencies. So documentation matters. That's why, like we are signing the contract. And alternatives first. That is not like instead of going to the final, no, to the no, like the maximum decision making of no, like seizure of the building or no seizure of the project. So a remedial measure like no, like a fine, like fine, collecting the fine, or no, like paying the compensation, so that can be done. So whichever alternative is available on the first basis, so that can be taken. So modern trends is no, like digital governance is there in before people no, like companies and no government agencies which has given the contract will usually no, like go to the courtrooms. They will go to the court no, campus and appear before the no, like the judges and the lawmakers. But now through digital, no, like everything is being governed. Collaborative approach, no, like instead of no, like uh, winning over the situation, so always collaborative approach is a better way. So if your company has no, like done something wrong, accept it, pay the compensation, and go on with the project. Otherwise no, like if you're not accepting it, and if you're not ready to pay the compensation, if the no, like the thing goes to the no, to the court, which is no, like done by the government, then you have to no, like pay more by at that time. So better no, like go with the collaborative manner. So, to conclude, administrative law is all about the accountable government. It means government is also accountable in the project, in the contract. So, since it is no, like the offer is made by the government, it doesn't mean government has all the no, like the power and the no, like the eligibility to take any decision as it likes. No, it's not like that. So every citizen deserves fair treatment by government agencies. Every decision maker must follow proper procedures. Every action must be subject to appropriate review. And democracy depends on the rule of law, not the rule of individuals. Because here, even the government is seen as an individuals. They are getting into contract, right? Any party, any person, any agency, any organization, when they are getting into contract, they are seen as individuals. So yes, I have covered the maximum about the administrative law. So I'll be here for next 2 to 3 minutes. If you have any questions, you can ask.
Yes, madam. Hello?
Yes.
Yes, I don't have any question actually, but it will be very important if you can share this note with us so that we can use it for reference, in the
Sure.
future.
I'll just no, like send this. I'll just forward this these notes to the administrator, and they will be forwarding it to you.
Yeah,
Last time I didn't forward because no, like this was a continuation of the last session. So I thought let me complete no, like everything, and then no, like I'll give you the final notes.
yeah, it is going to be very important. Sometimes in offline we can be reading and trying to
Sure,
understand.
definitely. I'll share it. I'll share it.
All right. Okay.
Mhm. Any other questions?
Yes, ma'am. Please.
Yes.
Can you repeat, please? Ombudsman institution.
Ombudsman.
Institution.
Ombudsman discretion. That is the
Yes.
decision taken by the ombudsman. That is the verdict, the judgment given by the ombudsman. So before like take the issue to the court, which will take a lot of time to like to give the verdict or no, and you have to invest. I mean, the cost of like court proceedings will like will be too high. So for that reason, companies or any individual can like take the issue to the ombudsman or like like the third party mediators. So they will like mediate, negotiate between you and the other party, and they can give the judgment. There is ombudsman discretion. Clear?
Yes, ma'am. Thank you.
Ma'am,
Yes.
ma'am, the ombudsman judgment is applicable for all country or specific country?
That depends. Most countries will be having this ombudsman. Most countries.
In case India will happen, how to approach the ombudsman case will be how will be approach the
Through like we have lawyers, you have like other legal legally appointed parties or there, agencies or there. So through them you can like take the case to the ombudsman. They will guide you.
okay, ma'am. Thank you.
Mhm.
Thank you.
Yeah. Okay, so yes, we can like end this session, and I'll see you in other session. Thank you and have a great weekend.
Thank you, ma'am.
Bye.